Union Territories, 239. Administration of Union Territories. 1. Save as otherwise provided by Parliament by law, every Union Territory shall be administered by the President acting, to such extent as he thinks fit, through an administrator to be appointed by him with such designation as he may specify. 2. Notwithstanding anything contained in Part 6, the President may appoint the Governor of a state as the administrator of an adjoining Union Territory, and where a Governor is so appointed, he shall exercise his functions as such administrator independently of his Council of Ministers. 3*239a. Creation of local legislatures or Council of Ministers or both for certain Union Territories. 1. Parliament may by law create the Union Territory of 544.
Puducherry a body, whether elected or partly nominated and partly elected, to function as a legislature for the Union Territory, or b. a Council of Ministers, or both with such constitution, powers and functions, in each case, as may be specified in the law. 2. Any such law as is referred to in Clause 1, shall not be deemed to be an amendment of this Constitution for the purposes of Article 368 notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. ___1. Subs. By the Constitution, 7th Amendment Act, 1956, s. 17, for the heading, the States in Part Century of the First Schedule, W. E. F. The 11th of January 1956. 2. Subs. By s. 17, Ibid. For Art. 239 W. E. F. The 11th of January 1956. 3. Ins. By the Constitution, 14th Amendment Act, 1962, s. 4 W. E. F. The 28th of December 1962. 4. Subs. By the Goa, Daman and Dew Reorganization Act, 1987 18 of 1987 s. 63, for any of the Union Territories of Goa, Daman and Dew and Pondicherry, W. E. F. The 30th of May 1987. 5. Subs. By the Pondicherry Alteration of Name Act, 2006 44 of 2006 s. 4, for Pondicherry, W. E. F. The 10th of January 2006. Article 239A has been made applicable to Union Territory of Jammu and Kashmir by the Jammu and Kashmir Reorganization Act, 2019 34 of 2019 s. 13 W. E. F. The 31st of October 2019 112. 113 The Constitution of India Part 8. The Union Territories 1-239A. Special provisions with respect to Delhi. 1. As from the date of commencement of the Constitution 69th Amendment Act, 1991, the Union Territory of Delhi shall be called the National Capital Territory of Delhi, hereafter in this part referred to as the National Capital Territory, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. 2. There shall be a legislative assembly for the National Capital Territory, and the seats in such assembly shall be filled by members chosen by direct election from territorial constituencies in the National Capital Territory. B. The total number of seats in the Legislative Assembly, the number of seats reserved for scheduled castes, the division of the National Capital Territory into territorial constituencies including the basis for such division, and all other matters relating to the functioning of the Legislative Assembly shall be regulated by law made by Parliament. 2. Seats shall be reserved for women in the Legislative Assembly of the National Capital Territory of Delhi. B. As nearly as may be, 1/3 of the seats reserved for the scheduled castes in the Legislative Assembly of the National Capital Territory of Delhi shall be reserved for women. C. As nearly as may be, 1/3 of the total number of seats to be filled by direct election in the Legislative Assembly of the National Capital Territory of Delhi, including the numbers of seats reserved for women belonging to the scheduled castes, shall be reserved for women in such manner as Parliament may by law determine. C. The provisions of Articles 324 to 327 and 329 shall apply in relation to the National Capital Territory, the Legislative Assembly of the National Capital Territory and the members thereof as they apply, in relation to a state, the Legislative Assembly of a state and the members thereof respectively, and any reference in Articles 326 and 329 to appropriate legislature, shall be deemed to be a reference to Parliament. __1. Arts 239AA and 239AB ins. By the Constitution 69th Amendment Act, 1991, s. 2 W. E. F. The 2nd of January 1992. 2. Ins. by the Constitution 106th Amendment Act, 2023, S. 2. Date yet to be notified. 114 The Constitution of India Part 8. The Union Territories 3(8) Subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the State List or in the concurrent list insofar as any such matter is applicable to Union Territories except matters with respect to entries 1, 2 and 18 of the State List and entries 64, 65 and 66 of that list insofar as they relate to the said entries 1, 2 and 18. B. Nothing in subclause 8 shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a Union territory or any part thereof. C. If any provision of a law made by the Legislative Assembly with respect to any matter is repugnant to any provision of a law made by Parliament with respect to that matter, whether passed before or after the law made by the Legislative Assembly, or of an earlier law, other than a law made by the Legislative Assembly, then, in either case, the law made by Parliament, or, as the case may be, such earlier law, shall prevail and the law made by the Legislative Assembly shall, to the extent of the repugnancy, be void, provided that if any such law made by the Legislative Assembly has been reserved for the consideration of the President and has received his assent, such law shall prevail in the National Capital Territory, provided further that nothing in this subclause shall prevent Parliament from enacting at any time any law with respect to the same matter including a law adding to, amending, varying or repealing the law so made by the Legislative Assembly. 4. There shall be a Council of Ministers consisting of not more than 10% of the total number of members in the Legislative Assembly, with the Chief Minister at the head to aid and advise the Lieutenant Governor in the exercise of his functions in relation to matters with respect to which the Legislative Assembly has power to make laws, except in so far as he is, by or under any law, required to act in his discretion, provided that in the case of difference of opinion between the Lieutenant Governor and his ministers on any matter, the Lieutenant Governor shall refer it to the President for decision and act according to the decision given thereon by the President, and pending such decision it shall be competent for the Lieutenant Governor in any case where the matter, in his opinion, is so urgent that it is necessary for him to take immediate action, to take such action or to give such direction in the matter as he deems necessary. 115 The Constitution of India Part 8. The Union Territories 5. The Chief Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Chief Minister, and the ministers shall hold office during the pleasure of the President. 6. The Council of Ministers shall be collectively responsible to the Legislative Assembly. 1.7.8 Parliament may, by law, make provisions for giving effect to, or supplementing the provisions contained in the foregoing clauses and for all matters incidental or consequential thereto. 2b. Any such law as is referred to in subclause 8 shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. 8. The provisions of Article 239b shall, so far as may be, apply in relation to the National Capital Territory, the Lieutenant Governor and the Legislative Assembly, as they apply in relation to the Union Territory of 3 Puducherry, the Administrator and its Legislature, respectively, and any reference in that article to Clause 1 of Article 239a, shall be deemed to be a reference to this article or Article 239ab, as the case may be. 239ab. Provision in case of failure of constitutional machinery. If the President, on receipt of a report from the Lieutenant Governor or otherwise, is satisfied, 8. That a situation has arisen in which the administration of the National Capital Territory cannot be carried on in accordance with the provisions of Article 239a or of any law made in pursuance of that article, or b. That for the proper administration of the National Capital Territory it is necessary or expedient so to do. The President may by order suspend the operation of any provision of Article 239a or of all or any of the provisions of any law made in pursuance of that, blank, underscore, blank, 1. Subs. By the Constitution 70th Amendment Act, 1992, S. 3, for, 7th W. E. F. The 21st of December 1991. 2. Ins. By S. 3, Ibid. W. E. F. The 21st of December 1991. 3. Subs. By the Pondicherry Alteration of Name Act, 2006-44 of 2006 S. 4, for, Pondicherry, W. E. F. The 10th of January 2006. 116 The Constitution of India Part 8. The Union Territories article for such period and subject to such conditions as may be specified in such law and make such incidental and consequential provisions as may appear to him to be necessary or expedient for administering the National Capital Territory in accordance with the provisions of Article 239 and Article 239A. 239b. Power of Administrator to promulgate ordinances during recess of Legislature. 1. If at any time, except when the Legislature of Union Territory of 3-2 the Puducherry is in session, the administrator thereof is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require, provided that no such ordinance shall be promulgated by the administrator except after obtaining instructions from the President in that behalf. Provided further that whenever the said legislature is dissolved, or its functioning remains suspended on account of any action taken under any such law as is referred to in Clause 1 of Article 239A, the administrator shall not promulgate any ordinance during the period of such dissolution or suspension. 2. An ordinance promulgated under this article in pursuance of instructions from the President shall be deemed to be an act of the legislature of the Union Territory which has been duly enacted after complying with the provisions in that behalf contained in any such law as is referred to in Clause 1 of Article 239A. But every such ordinance, a, shall be laid before the legislature of the Union Territory and shall cease to operate at the expiration of 6 weeks from the reassembly of the legislature, or if, before the expiration of that period, a resolution disapproving it is passed by the legislature, upon the passing of the resolution, and b. may be withdrawn at any time by the administrator after obtaining instructions from the President in that behalf. 3. If and so far as an ordinance under this article makes any provision which would not be valid if enacted in an act of the legislature of the Union, ___1, ins. by the Constitution 27th Amendment Act, 1971, s. 3 W. E. F. the 30th of December 1971. 2. Subs. by the Goa, Damon and Due Reorganization Act, 1987 18 of 1987 s. 63, for, a Union Territory referred to in Clause 1 Article 239A, W. E. F. the 30th of May 1987. 3. Subs. by the Pondicherry Alteration of Name Act, 2006 44 of 2006 s. 4, for, Pondicherry, W. E. F. the 10th of January 2006. 117 The Constitution of India Part 8. The Union Territories territory made after complying with the provisions in that behalf contained in any such law as is referred to in Clause 1 of Article 239A, it shall be void. 124 240. Power of President to make regulations for certain Union Territories. 1. The President may make regulations for the peace, progress and good government of the Union Territory of, a. the Andaman and Nicobar Islands, 3, 4, 5, 6, 8, 9, 10 b. Lakshadweep, c. Dadra and Nagar Haveli and Daman and Diu, D.E. 7 Puducherry F.G. provided that when any body is created under Article 239A to function as a legislature for the Union Territory of 7 Puducherry, the President shall not make any regulation for the peace, progress and good government of that Union Territory with effect from the date appointed for the first meeting of the legislature. ___. 1. Clause 4 ins. by the Constitution 38th Amendment Act, 1975, s. 4 with retrospective effect. This amendment was omitted by the Constitution 44th Amendment Act, 1978, s. 32 W. E. F. the 20th of June 1979. 2. Subs. by the Constitution 7th Amendment Act, 1956, s. 17, for art. 240 W. E. F. 11111956. 3. Subs. by the Locative, Minicoy and Amindivi Islands Alteration of Name Act, 1973 34 of 1973 s. 4, for entry B. W. E. F. the 11th of January 1973. 4. Subs. by the Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Act, 2019 44 of 2019 s. 4 I. W. E. F. the 26th of January 2020 for entry C, which was ins. by the Constitution 10th Amendment Act, 1961, S.3 W. E. F. the 8th of November 1961. 5. Omitted by the Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Act, 2019 44 of 2019 s. 4 E. W. E. F. the 26th of January 2020. 6. Ins. by the Constitution 14th Amendment Act, 1962, S. 5 W. E. F. The 16th of August 1962. 7. Subs. By the Pondicherry Alteration of Name Act, 2006 44 of 2006 S. 4 for Pondicherry, W. E. F. The 10th of January 2006. 8. The entry F relating to Mizoram omitted by the State of Mizoram Act, 1986 34 of 1986 S. 39 W. E. F. The 20th of February 1987. 9. The entry G relating to Arunachal Pradesh omitted by the State of Arunachal Pradesh Act, 1986 69 of 1986 S. 42 W. E. F. The 20th of February 1987. 10. Ins. By the Constitution 14th Amendment Act, 1962, S. 5 W. E. F. The 28th of December 1962. 118 The Constitution of India Part 8. The Union Territories 1 provided further that whenever the body functioning as a legislature for the Union Territory of 2 Puducherry is dissolved, or the functioning of that body as such legislature remains suspended on account of any action taken under any such law as is referred to in Clause 1 of Article 239A, the President may, during the period of such dissolution or suspension, make regulations for 3 the peace, progress and good government of that Union Territory. 2. Any regulation so made may repeal or amend any act made by Parliament or any other law, which is for the time being applicable to the Union Territory and, when promulgated by the President, shall have the same force and effect as an Act of Parliament which applies to that territory. 241. High Courts for Union Territories. 1. Parliament may by law constitute a High Court for a 5/4 Union Territory or declare any court in any such territory to be a High Court for all or any of the purposes of this Constitution. 2. The provisions of Chapter 5 of Part 6 shall apply in relation to every High Court referred to in Clause 1 as they apply in relation to a High Court referred to in Article 214 subject to such modifications or exceptions as Parliament may by law provide. 6. 3. Subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature made by virtue of powers conferred on that legislature by or under this Constitution, every High Court exercising jurisdiction immediately before the commencement of the Constitution 7th Amendment Act, 1956, in relation to any Union Territory shall continue to exercise such jurisdiction in relation to that territory after such commencement. 4. Nothing in this article derogates from the power of Parliament to extend or exclude the jurisdiction of a High Court for a state to, or from, any Union Territory or part thereof. 242. Courg. Omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. Blank, underscore, blank, 1. Ins. By the Constitution 27th Amendment Act, 1971, S. 4 W. E. F. The 15th of February 1972. 2. Subs. By the Pondicherry Alteration of Name Act, 2006 44 of 2006 S. 4. For Pondicherry, W. E. F. The 10th of January 2006. 3. Subs. By the Constitution 27th Amendment Act, 1971, S. 4. For any existing law, W. E. F. The 15th of February 1972. 4. Subs. By the Constitution 7th Amendment Act, 1956, S. 29 and SCH. For, state specified in Part C of the First Schedule, W. E. F. The 11th of January 1956. 5. Subs. By S. 29. And SCH. Ibid. For, such state, W. E. F. The 11th of January 1956. 6. Subs. By S. 29. And SCH. Ibid. For CLS. 3 and 4 W. E. F. The 11th of January 1956.